Hare Krishna. Welcome to Tax YouTube channel. This is C. Rohan R. Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Today we are going to discuss special video, special topic on appearance before appellate authority. Yes, so let's dive into it. Let me allow to share my screen. Yes. So appellate authority, right? Appellate authority or tribunal is not merely a matter of legal representation. It is what a reflection of preparation, professionalism, court etiquette, and effective communication. A well prepared representative not only strengthens what client's case but also creates a positive impression before the forum. So success in appellate proceedings depends as much as understanding the law and facts as on the manner of presentation, conduct, and strategic handling of the matter. Means only presentation is also not a matter, but understanding of the law and facts is also what important. So let's see the practical aspect serves as a useful guide for effective representation before appellate forum. So whatever we are going to discuss is now from next slide onwards are a practical aspects to as a useful guide for effective representation before the appellate forum. So let's start with it. First, preparation before appearance. So knowledge about the law on a particular matter is what important. Understanding of the facts of the case is also equally important. Check for judicial decisions not considered earlier. It is advisable to have a printed copies of judicial decisions with you. Prepare a summary of entire case in about 3 to 4 pages and also short notes. So whenever you require, you can go through it or you can also brief at the forum. So next, let's understanding the appellate authority. So know and understand the adjudicating or appellate authority. How one can know by reading his or her previous judgments, is going through whatever previous judgments, you can see the approach of the appellate authority. So by that we can understand and able to know certain things. Visit the location, very important. Visit the location of the forum before actual date, if feasible and possible, to familiarize the place. Meeting the superintendent, possibly the adjudicating authority or appellate authority, may be also advisable and helpful. So while addressing, it is advisable to address the authority as a sir or any respectful salutation or title that is customary. That is also equally count. Next, professional conduct. Wearing a black coat except summer season, I think exception to it, that April to August period, sorry, so that you can wear a formal without a black coat. So, but dress code is prescribed for ITAT representation. Spoken words are more expressive and add more value than your written literature. So one need to work on your the spoken ability. Maintain the professional demeanor throughout the proceedings. That is very important. So very we need to work on these things before means anyone who are now exploring or want to go into litigation, you need to prepare on these factors. Let's see in case matter listed before tribunal. So meeting the court master before the tribunal commences may be advisable. Meeting the departmental representative will also help you a lot. So members on the bench should be addressed as what? My lord or your honor. Stand whenever the member bench enter or leave the courtroom and bow your head to acknowledge them. Very important etiquettes. Let's, our next slide is what about the general etiquettes. So no audio, video recording or photography is allowed. Mobile phone usage is also prohibited. Avoid the disrespectful posture or conduct. Never ever interrupt the authority. While anything they are communicating, don't get interrupted by any way or any conduct. Sitting with a crossed legs considered as disrespectful. Very, very important such things. Then types of hearing. There are four types of hearing. We can say that early hearing, clubbing or tagging of similar matters, condonation of delay applications, or regular hearing strategy. We will see one by one. So that is the methodology to represent varies with the type of hearing, as I say. So in early hearing, clearly explain the reasons for urgent hearing. Request clubbing or similar matters for efficiency and demonstrate the practical justification for your procedural request. Very, very important. In condonation of delay, the applicant will have to what furnish the reasons that account for delay. Application should be supported by an affidavit that is very much important and other documentary evidence to substantiate the reasons adduced. Condition is not a matter of right. Okay, your condonation is not a matter of right. So sometimes it cost means whatever condonation costs are there are imposed by the tribunal or court for entertaining your condonation application. But we remember that condonation is not a matter of a right. So your request will be very respectful. Next, regular hearing. So here there are no limitation as such on time for presenting your arguments at regular hearings. Submit your own case facts and present your arguments and then only give reference to case laws which you are relied upon. Means whenever you are representing, don't directly relate the relevant case laws and that these are the similar to the these case laws facts of that. First, you on your own, whatever the facts that you need to first submit and present your grounds of appeal, arguments to the authority, and then you can relate or reference to the relevant case laws you are relied upon. That is very important. Speak slowly, softly, and clearly as much as you can. Satisfactory address the question raised by adjudicating or appellate authority and not to launch a counter question or debate over it. Many times, if the person, it is, depends on a subjective, means person is like only that, personality is like that, then it may happen that many times we start arguing or start debating whenever a appellate or adjudicating authority has any points. But that we should not do at that level as far as I feel. So first address the question raised by that and do not whatever you feel, whatever you keep present it over in front of them, but don't go into the counter question or debate over it. Please taken care of it. Each ground should be submitted and supported with the facts and or law. Means don't make any statement in a haphazard way or in a lightly manner. Don't take it very lightly. Your each statement should be, or whatever your ground of appeal should be submitted and supported with the very facts of the case and or a law wherever possible. Never interrupt an adjudicating authority or appellate authority, as I said earlier. If matters are heard partly before, then it is important to summarize the submission made in a previous hearing. Very important. So CA should always keep all the relevant documents, statutory provisions, circulars, and case law, whatever he are on, depending on what, relying on that which he intends to rely upon. Means that need to be taken with you. Means that need to be with you. Means printed format is always a prefer. You should have a printed copies of it with you. That is very important. So documentation and management is support each ground with facts and legal provisions, keep statute circulars as already we discussed, summarize the prior submissions in part, means part heard matters earlier. So, in conclusion, representation before appellate forums demands what? A blend of technical competence, procedural awareness, very important. What it requires? Technical competence, definitely, procedural awareness, and the professional decorum also. How you present, how you look, how your facial expressions are while you are communicating before the appellate authority, that everything matters a lot. So while substantive legal arguments remain the backbone of any case, effective advocacy is equally shaped what by the preparation, respectful conduct, and clarity in communication. So discipline and thoughtful approach not only enhance your credibility of the representation, but also contributes what significantly to the efficient administration of justice. So be please take note of it, all such things. Thank you so much for patient hearing. If you have any questions, suggestions, observations, then do let me know via WhatsApp, email, or you can also comment below the video. Hope you are gaining valuable knowledge from all these updates and video series which we are conducting on a Tax YouTube channel. So stay tuned to the Tax YouTube channel. If you have not yet subscribed, then do subscribe for latest updates and video series like this. Thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.